Hello, my name is Michael Tesoro and I prepared this video case note entitled ASIC Falls Short in Conflicted Remuneration Case. What I'll be looking at is the recent case by ASIC against the Commonwealth Bank of Australia alleging that they had breached these relevant provisions. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice to Tesoro Legal Consulting for the last 15 years, and I help companies with competition and consumer law matters. Also do a little bit of ASIC work. I'm a bit of a dabbler in the side in the ASIC area. Prior to that, I worked at the ACCC 15 years in a variety of roles, including as Director of Enforcement. Now in the presentation, I'll go through the background facts, then look at the decision, and then finish with the implications of the case. Now, the background of the case was that ASIC alleged that CBA had engaged in conduct in breach of the conflicted remuneration provisions of the corporations law, and these breaches related to alleged benefits which were provided by Colonial First State Investments Limited to the Commonwealth Bank in relation to the MySuper superannuation product called Essential Super. And ASIC alleged that between 2013 and 2019, Colonial First State gave CBA benefits which they accepted, which were both monetary and non-monetary benefits, which ASIC alleged could have reasonably been expected to influence the financial product advice which was given to retail customers. And there was three types of benefits. Firstly, choices in action, which were called the promises. That's a non-financial benefit, non-monetary benefit. Cash transfers from Colonial First to CBA, and journal entries totaling $55 million. Now, CBA's defence was quite simple. It just claimed that the impugned benefits could not have reasonably been expected to influence either the choice of financial products or the provision of the financial advice. Now, Anderson starts off looking at the purpose of the legislation. He makes the point that the legislation was brought in due to concerns about conflicts of interest in the financial sector and the quality of product financial advice, and a belief that the mere disclosure of conflicts of interest was not enough. Rather, the legislature believed the only way to combat poor advice and poor consumer outcomes was to prohibit conflicted remuneration. And he also notes that the choice of the words conflicted remuneration suggests a deliberate choice or deliberate intention by Parliament to focus on situations which generated a genuine conflict of interest. So situations that might be theoretical or potential situations wouldn't be covered. Rather, what the legislation is seeking to do is to get to genuine conflicts of interest which cause consumers some detriment. Now, a very helpful part of the judgment is Anderson going through and identifying the features of the conflicted remuneration provisions. So I'll go through them now, but this is quite helpful law for people who don't have a good understanding of the area. Firstly, there must be a benefit conferred, and benefits defined under Section 9 of the Corporations Act to relate to either monetary or non-monetary benefits, which is relevant to this case. Secondly, there must be an expectation that the benefit is reasonably expected to influence the choice of financial products. So it's really looking at form over substance. Thirdly, Section 963A has two limbs. The first being that there needs to be two or more financial products. So the section will not be enlivened unless there's a choice of different financial products. The second limb is that there needs to be some financial advice provided. So again, the section won't be enlivened if there is no financial advice being provided. Fourth, as I said earlier, it really is all about substance over form. We're looking at real conflicts of interest which cause detriment to consumers. It's not a question of looking at possibilities and theoretical concerns. The test to be applied is an objective, reasonable standard. So whether the benefit could reasonably be expected to influence the advice that was given to the retail consumer. 6, there must be a causal nexus between the benefit and the influence. 7th, the time at which is assessing various issues, namely whether the advice could reasonably be expected to influence, is the time when that was provided. 8th, again, you're looking at real tangible effect on the choice between different financial products. It's not looking at theoretical or the possibility of influence, it's looking at real situations. And ninth, and this is, I guess, important observation, is that what the legislation is trying to do is to improve the quality of financial advice while building trust and confidence in the financial industry. So that's what the legislation is seeking to do. That's why it's important to look at genuine situations of conflicts of interest. Now, the decision by Anderson is pretty comprehensive against ASIC. He says in paragraph 479 that ASIC has simply misconceived the purpose and application of the relevant provisions. It was never intended to operate between business units. And what you have to realise here is that Colonial First State is a subsidiary of Commonwealth Bank. So he's saying the legislation was only supposed to apply to totally separate legal entities, not entities that are part of the same consolidated group. Also, the fact that Essential Super was the only or the sole superannuation product which the CBA had meant that it had no ability for CBA to recommend Essential Super over another superannuation product. So, given there was only one product, the legislation could not apply. So he concluded that it followed that the impugned benefits and the circumstances in which they arose when objectively assessed meant there could not reasonably be expected to have been any influence on the choice of financial product. So at that stage, ASIC has lost his case. The judge went on and looked at other issues, and he concluded that the journal entries could not be considered to be a benefit under the terms of legislation because they didn't cause any transfer of value between legal entities. Rather, it was simply an accounting entry between two companies that were a member of the same consolidated group. He also concluded that the promises, the choices in action, and the cash transfers would not constitute benefits because they, in the first case, merely promised that funds would be moved, and secondly, they resulted in the movement of funds within the same entity. So there was no net increase in, I guess, the value that the CBA group had as a whole. So in that context, it couldn't be considered to be a benefit. Then he looked at the impugned benefits and whether they'd be capable of influencing the advice. And he comments that even if he's wrong on the first points, there was really no possibility of there being a real and tangible effect of influencing either the choice of the product recommended or the financial advice given. And this is obviously relevant that the staff who were selling the Essential Super product had no knowledge of the internal accounting allocation agreements within the group. So they had no reason to try and recommend one product over another because they weren't aware of what internal financial and accounting arrangements were being put in place. Also looks at the provision of financial advice and concludes that because Essential Super was the only superannuation product which the CBA was offering, there was no way the legislation could apply. You need two products to choose between in order for the relevant legislation to apply. And that's the thing, the legislation presupposes that there is a choice between financial products. And then he concludes that there can be no prospect of any alleged benefit influencing advice where there is only one product in existence within the group. Now, the disposition of the case, Anderson concludes at paragraph 555 that the ASIC sought to elevate form over substance. They've taken a case which is inconsistent with the language and purpose of the conflict remuneration provisions. They've ignored the circumstances, not only of the fact that it was the sole product being offered, but they've ignored the commercial realities of intercompany transfers. These are two companies which are part of the same corporate group. This is not the type of conduct that the legislation was seeking to attack. Also, they failed to establish on evidence that impugned benefits could reasonably be expected to have an influence on CBA's distribution of the Essential Super product. And clearly, the fact that it was a sole product and there were entities that were part of the same group meant that the conflicted remuneration provisions could not apply. Now, some commentary there. It's fair to say that ASIC's case failed at every hurdle along the way. They lost at every point. There were some other technical points which they also lost on in relation to grandfathering clauses, but it's a very comprehensive loss for ASIC. And the criticism by the judge that they sought to elevate form over substance as a concern, really regulators had to be looking at conduct that's causing significant consumer detriment. And here the view was that there couldn't have been any consumer detriment because there was no conflict of interest. The fact that CBA only had one product seemed to me to be a pretty decisive consideration. I'm surprised once ASIC was aware of that fact, why they pursued the case. Really, unless you've got two products, how can you have a conflict? I think the criticism that ASIC received from the judge that they were not recognising commercial realities, it's a criticism that's often levelled at the Australian Competition and Consumer Commission, so good to see ASIC's copying the same criticism. But here they weren't really looking at the commercial realities, looking at the way a consolidated group managed its accounts, the way funds were transferred between different groups. So that's surprising given their expertise in the area. And it just seems to me that there needs to be better case selection in ASIC, because I just can't see how a case like this gets to the federal court for determination, because it seemed on so many grounds ASIC's case theory was simply wrong. So that's a concern. They really need to be thinking through cases, and really, unless they can say themselves this conduct has caused significant detriment to consumers, they probably shouldn't be taking it. So that's all I've had. If you have any questions about this case or this presentation, feel free to give me a call or drop me an email. Bye-bye.